So thank you everyone for taking the time to join us today for the first webinar in the Growing the Ag Workforce series. My name is Meg McCosker and I'm the Ag Workforce Officer for Central Highlands and Central West Queensland. I form part of the Queensland Ag Workforce Network. So QAWN is actually I'd like to take time to acknowledge QAWN as our funding body for the Growing the Ag Workforce webinar and podcast series. QAWN is a government-funded, industry-delivered initiative that supports agribusiness to attract, train and retain workforce. So just to go over a few housekeeping rules, I have mentioned the muting the mics. We want you to take as much away from this webinar as possible. So I do invite your questions and your comments. Can I please ask that you all keep yourselves muted when Jay is presenting? And if you'd like to speak during the allocated time, allocated question time, that you use the raise hand function, which can be found in the reactions along the top of your screen. You'll see a reactions tab and there's a raise hand function there as well. So if you could just use that, and then either myself or Jay will invite you to speak, and that way we'll minimize the talking over each other. And then if you could keep yourselves on mute when you're not speaking, that will minimize the distractions and noise feedback. So today's webinar is going to be recorded and we will share that link with you over the coming days, and we welcome you to revisit the content yourself and also share with your colleagues. If you have any technical difficulties, can you please let me know either via the chat? Sorry, Michelle, if you could please just mute yourself quickly. I can hear a bit of feedback coming through. Thank you. Yeah, if you have any technical difficulties, let me know via the chat or emailing me, meg@sharpe.org.au, and I'll do my best to help resolve it for you. Otherwise, I'll put in the chat a little go-to how to get yourself out of a technical issue in shortly. So we invite you to have your video on, as it's always nice for Jay to be able to see the lovely faces and interact with people on the chat today. So with that, I think a good way to get the kind of the discussion rolling is for everyone to put in where you're tuning in from and your operation type, and that way Jay will be able to tailor some of the discussions today, if that's possible. So just in the chat function, which again is on the top of the banner screen.
Thanks, Meg.
No worries. Are you coming through? So
hi, everyone. I'll give you all a wave. Those that can see me, hopefully, give you all a wave. Thanks very much for your attendance. Thanks, Meg, for that introduction. Welcome, everyone. It's this is your first of your three-part webinar and podcast series that's being conducted. What I'm going to do is I'm going to share with you, so bear with me, we're using a PowerPoint presentation today, which I think Meg has sent out to you guys about an hour ago for you to have a look at. So I'm going to get that up first and hopefully everyone can see that. Can everyone see that? Yep. If you can't, give us a cooey or a wave or something. Everyone's good. Thumbs up. Excellent. Thanks very much for that. So look, we've got an hour today, guys, and we've got quite a bit to cover off on. I'm obviously doing your Workplace Relations 101 session. Like I said, we're going to use the PowerPoint, some assistance from the PowerPoint session today. As Meg said, if you do have any questions, just use the chat box there. Meg will probably pick them up more so than I will, because I'm presenting, and I'll try and answer some of those questions for you today if I can. If I can't do that, that's fine. Still put your questions in there. If I do not get to them today, I will get to them after the session, or within the next couple of days. I'll come back to you guys directly or through Meg and try and answer the questions for you. Just quickly, a little bit about us. I founded Sharpe Workplace Solutions back in 2004 from my kitchen table on a property that we have just outside of Oakey, because we saw a gap. I was practicing industrial relations in Brisbane for a period of time before I shifted back out this way being Oakey, Toowoomba, the Darling Downs region. we could see a real gap in providing some workplace relations support to particularly the small, medium-sized businesses in regional Queensland, which has now expanded out to regional Australia for us as well, so metropolitan and regional Australia. So from those beginnings, we expanded our business to have an office in Toowoomba and Brisbane, and operating within Queensland to across Australia. And we've got some international clients as well. But today, for you guys, is about Workplace Relations 101. That's what the webinar is about. And it's designed to provide you with an introduction to the workplace relations systems, the system, its organisations and the law. And then particularly we're going to work through, for you guys today, this employment life cycle. So let's get stuck into it. The system, if you look at that next slide there. So basically we've had or regulation for workplace relations since 1904 in Australia. So it's one of those topics, particularly from a political level, where you'll see a point of difference between those political parties. So what happens when we get a change of government? We get a change of legislation and we get a change of employment laws, because it's really that point of difference between the political parties. So much so that the current federal Labor government have introduced a bill into Parliament, and I won't bore you with that today, but introduced a bill into Parliament last week just to make some changes to the current legislation that we've got. But we've had a regulated workplace relations system since 1904. You're probably all familiar with the current system, or the name of the current system now, which is the Fair Work system, which commenced back in 2009. And what makes up the National Workplace Relations System is obviously the law, or the laws, which is the legislation, principally the legislation, which is the Fair Work Act of 2009. That's Commonwealth legislation or federal legislation. And then the other part of the system that I want to talk to you briefly about today are the organisations that make up that system. And I've listed them there on the slide for you. So the Fair Work Commission, the Fair Work Ombudsman, the Federal Court a few years ago, because of the overflow of work within the Fair Work Commission, they established a Fair Work Division within the Federal Circuit Court to deal with some of that pointy-end workplace relation litigation and workplace relations stuff. And I've also added there for you QAWN. You may or may not have heard of that tribunal here in Queensland, Queensland Civil Administration Tribunal, and also, of course, WorkCover Queensland. Just looking at, I suppose, what's essentially the main organisation. Well, there's two main ones, but this is the first one, and that's the Fair Work Commission itself. So that's the tribunal, guys, that's responsible for maintaining the safety net of minimum wages and employment conditions. It's the independent umpire for all things workplace relations. It deals with things like maintaining modern awards, minimum wage fixation. You probably all heard of the national wage case or the annual wage decisions, generally handed down in June and applying from the 1st of July when they increased rates to the awards. They deal with dispute resolutions. They deal with claims then that might come in from employers or employees. And in particular, you'll see there on the list, unfair dismissal and general protections, and also bullying and sexual harassment complaints that might come in. So the Fair Work Commission has for some years now had the power to deal with bullying complaints that might arise out of the workplace. Not so much sexual harassment complaints. They are dealt with generally by a QAWN. However, late last year, they increased the powers and the jurisdiction of the Fair Work Commission to now include sexual harassment complaints. But they've always, some years, whether it's the Fair Work Commission or the Australian Industrial Relations Commission or the Workplace Authority, those previous entities before it became the Fair Work Commission, all had powers generally to deal with modern awards, wage fixation, dispute resolution and unfair dismissals and general protection claims. The next organisation I just want to talk to you about, which I think is really important for businesses, whether it's small, medium or large, is the Fair Work Ombudsman. So this is one of the other main organisations, which I can best describe for you as the Industrial Relations Police. They have a couple of different sections. One is they have inspectors that do wage compliance inspections and audits and follow up on any complaints or concerns in regard to wages with businesses and employees. And then they've also got a prosecutions department as well. So if you think of the Queensland Police Service, you've got the cops on the beat, then you've got the prosecutions. It's similar in terms of the Fair Work Ombudsman. There's sort of two arms to it. So they've got these inspectors, which are like the cops on the beat. They've got power to enter your premises if you've got a workplace or your workplaces. They can inspect and copy employment records, interview business owners or managers and employees. And then subject to what they find, they can issue fines and penalties, some of which can be on the spot. Generally, they'll issue improvement notices. Firstly, give you an opportunity to try and correct any issues or concerns in regards to wages before it heads off to prosecution. But there, you may have heard about the Ombudsman. They get themselves in the media a bit in relation to prosecuting, particularly some of the media coverage that we've seen over the last few years. Probably started with the 7-Eleven chains. They were in the media a fair bit. Some cafes and hospitality businesses, different businesses that got themselves in the media for underpayment of wages. There is not a week that goes by that we don't get notice through our subscriptions as Workplace Relations Advisor of the Fair Work Ombudsman not prosecuting a business somewhere in Australia and heading off to court or getting damages or fines and penalties awarded and underpayment of wages. So you could be dealing with, in the good old days, you were dealing with someone generally local, for whatever that might mean for you guys. So there was an inspectorate based out of Toowoomba here and some of the regional centres. Of course, these days, you could be dealing with an inspector that's sitting in an office in Hobart or an inspector sitting in an office in Adelaide, okay, that could be contacting you. So they may not physically come onto the property or onto the business site and knock on your door, but they may be contacting you through technology in terms of requiring to see time and wage records. So that's the Ombudsman. The other couple of entities that make up the system, like I said, they're probably associated entities or organisations to the National Workplace Relations System. And that's QCAT. They hear those complaints, discrimination, sexual harassment, bullying as well, vilification and victimisation type complaints. And then, of course, you probably have all heard of WorkCover Queensland. As a business, you need to be insured. You would be insured through WorkCover Queensland and the workers' compensation legislation that applies. They perform those regulatory functions as part of WorkSafe, which is an agency of the Queensland Government. I haven't got a question section there, but if anyone's got any particular questions about that, just shoot them through. And I'm sure Meg will pick them up. And because I'm going to jump into, guys, the next section for you. So the term employment life cycle or work-life cycle may be quite foreign for a lot of you because it's one of those sort of trendy HR terms HR practitioners and consultants like to use. But essentially what it means is that there are 3 phases for a worker or an employee when they throughout their employment life. The first one is obviously entry into a business or into an organisation. And we've broken that down, particularly for the purposes of today, but as being identifying for you risks associated with recruitment, selection and onboarding. The second phase is then what happens during their time with you as an employer and what are the risks associated with managing an employee essentially on a day-to-day basis. And then the third part of the cycle, of course, is what happens when the employment relationship comes to an end, guys, and what that looks like and what are the risks associated with that. So for the purposes of the webinar today, we've applied the risk management approach or lens, as you can probably see. Like I said, we've only got an hour and we've tried to jam quite a bit in for you. So we've just looked at what might be some of the key risks that you might have in your business, and hopefully we can give you some tips today as well about how to actually reduce or minimise those risks in your business. So let's look at this first phase. So this is a worker or an employee coming into the business. And there's 3 sections, so recruitment, selection and onboarding. So again, there's 3 steps as part of that entry of a worker into the business. Now, guys, you've got a presenter as part of this series who's a specialist, I understand is a specialist in this particular area, and so they'll no doubt dig deeper. So get to that session as well, please, than what we're going to do here. But look, I recently read an article where it was identified that the average cost of recruitment at the moment sits at around $23,000, and it takes on average around 82 days to get someone from recruitment to selecting to onboarding. So basically to get them in and start getting them working in your business. Okay. So obviously the risk here is that not finding the right person, okay, which we all do, which we all have done or we do. So not finding that right person can be very expensive and very time consuming for your business. So basically managing the risk in your organisations when it comes to employment really starts up front at this first phase, okay? And you're not always going to get it right. Like I said, you're not always going to get it right, and we will employ people that aren't the right fit for the business. Maybe it's cultural fit, or they might not have the right skills and abilities. But there's certain things that we can do to try and make sure that we've got the right person coming into the business. So as with anything in life, planning's key, for me anyway. Planning's important. So planning as a business, planning what the primary purpose is of the role or of the position that you've got vacant, or might be multiple positions. Planning and taking some time up front to think about what type of employment you need in the business as well. So whether that's a full-time or a part-time or casual, whether it's permanent or temporary, or, you know, for some of the you guys, it might be seasonal workers that you'll need. Looking at obviously the attributes, so the qualifications and licenses and the experience of a potential employee, and then of course their pay and conditions. And so why do we do that? Because if you sit down and spend a few days or a week, it might take you a week or so to do that. You may need to get some advice in relation to settling all that information and in putting all that in place. But if you do that, then you know you're going to the market, okay, with a job advert, if you're doing it that way, or if you're going to an employment agency, or however you may be recruiting, you're doing that in a clear, accurate and informative way. So you're going to the market and you know what you want. Now, as the little tick box there says that you can use a position description template. So look, you can, download those. They can come in starter packs. But if you sit down and use that position description, this is what I would do. I'd sit down with a position description template or a piece of paper, it doesn't really matter, and just scope out what is the role. Spend that time up front to scope all that out. Because the last thing you want to do is go to the market and then have candidates ring up and then start talking to you about, well, what's involved in the role, what are the terms and conditions of the role, is there accommodation, is there a vehicle, do you shut down over Christmas, what are the leave arrangements, what are the expectations. So the more work that you can actually do up front, okay, the better it's going to be. The next phase, or the next step in terms of entering a worker into your business or an employee into your business, is obviously the selection part. So this is where we shortlist, we conduct interviews and do the reference checks. So sadly, people today are always, as you're probably aware, looking for some type of angle, some way to complain or sue someone or sue a business. This goes for potential candidates as well. So again, being properly prepared at this step is also critically important for your business, so that you get the right person and you don't end up with some sort of, spurious or unwarranted claim of discrimination from someone who's disgruntled because they didn't get the job, because they think they didn't get the job because, you know, of their gender or their age or their race, or anything like that. Okay. Now, this is probably going to be a little bit hard, but can anyone tell me what merit selection is? Does anyone know what merit selection is, or they're prepared to put that in the chat for me before I give you the answer, if we can? Because I've used that term up there, merit selection and hard and soft skills.
If you'd like to speak up, you can use the raise hand function. Otherwise, I'm monitoring the chat.
So essentially merit selection is you picking the person. So what you're doing is you're selecting the best person for the job based on their ability to perform the work. Okay, that in a layman's terms, that's what it actually means. So when you're reading a resume, that only gives you a summary of a potential employee's hard skills. So it might say, yes, I've got the chainsaw ticket, I've got the ACDC licence, you know, handling chemicals, I've got the qualification in animal husbandry, I've worked for Stanbroke for the last 4 years and things like that. Okay, so that's great, but interviewing people gives you a much better understanding of their soft skills, guys. And what I mean by soft skills is, you know, you're going to get an idea of how they communicate, how they present themselves. You might get an idea of their personality or get a gauge on their personality. Okay, so getting the most qualified, experienced person is not always the best fit if you're just reading off a resume or a CV, because whilst they may have all the qualifications that's necessary to do the job, if you're not assessing in some way those soft skills as part of your selection process, you may end up with a highly qualified person who just simply can't work with other people. So what happens is you've got this, you know, really qualified expert mechanic coming on board into the business, but the only way he or she can communicate is to yell and scream at all the co-workers, okay, which ends up in some disputation for you as a business and a cost for you as a business. So it's really important to, I suppose, test the veracity or check as best as you can both the hard and the soft skills. And of course, technology is our friend in that regard now. So we can do that telephone, Zoom, depending on where you are. I'm still a good believer of face-to-face. But obviously, you know, depending on where you are, you may want to do your interviews via telephone or Zoom, at least Zoom or Teams if you can, and you can see them, read some body language. The reference checks, they're really, really important. We do some recruitment for our clients. We're not, I wouldn't say we're specialists in the recruitment field. Like I said, you've got someone presenting in the next session, I think, in relation to that. We still do some recruitment for some of our clients, though. We still get applications come through and the referees are friends or, you know, colleagues or co-workers. So what's really important here, guys, is to check the veracity of the referees, but in particular, what I mean by that is their status within the business of the organisation. So firstly, use business referees, contact business referees. And secondly, if you're unsure from the application of the resume, whether that referee was a co-worker, a supervisor or a manager, then it's really important to clarify that. And you can clarify that with the candidate themselves and ask them what the position of the referee was in that role or in that business. And then you can check that then with the actual referee when you go to call them or contact them, okay, to speak to them, to do your checks on the potential candidate. And guys, don't be frightened. I know, like I said, everyone's looking for an angle these days. There are certain things that you do have to sort of try and steer clear of in terms of what you can and you can't ask, candidates, and you've got to be careful about how you do that. But you can still definitely directly ask candidates and also referees to check that information or check the veracity of that information, issues around whether they were subject to any disciplinary action, whether they took any time off work, whether there was any conflict with co-workers within the workplace. So don't be frightened to still ask those questions. And as the tip is I've got there, develop and use a merit selection matrix, an interview plan, and a referee check plan. So you'll see, guys, throughout this session, I'm a bit of a plan person, like to be prepared. And again, like I said to you, if the statistics or the information is saying that it's costing 23K and 82 days or 3 odd months to recruit someone coming into the business. So spending some time up front to get all this stuff in place is really going to help protect your business. Okay. That last step with the entry into the business is the onboarding. Okay. So once you've selected a candidate, it's really important that they're properly or thoroughly onboarded, guys. So again, technology can be our friend here, if in a position to be able to use it. And my tip is the more you can do before part of this onboarding, before they come to site, the better, actually. So with that, if you look at this slide, so there's 3 parts to that. Commitment, so this is where we do the formal offer and acceptance, gather the necessary or compliance information from a candidate, superannuation, tax file, bank, of underlying fitness for work. So you can ask them in that questioning, you can ask them in relation to whether or not they have any medical condition or conditions that may impact on or prevent them from performing the inherent requirements of the work. So don't be frightened of that. The induction step, so this is where you provide your essential information about your business, the work environment, what they're coming into, and in particular the expected standards of behaviour. Okay, and then orientation generally occurs on day 1, so when they land on site. Okay, so you welcome and assimilate them into the workplace, might be setting up the accommodation for them, introducing the co-workers, the supervisors, or if you're actually the owner of the business. Now, you might be thinking, why do you want to do as much as you can prior to them commencing work? Well, the short answer is it may save you a lot of time and a lot of money. Okay, because if you leave all this and they love on site, and particularly if you're remote, regional, okay, and they come out and they come on site and you've got to go through this. So you might spend a full day or 2 days doing this, and they'll be on the clock. Essentially, they'll be on the clock and you'll be paying them to do that. Okay. The other part of it is that by doing it prior to they come to site, so sending out the formal offer and acceptance, you're wanting to get commitment. Okay. You want them to show that they're committed to the job. And by sending them out then as part of an induction of site, the information about your staff handbook or your code of conduct and your policies and procedures, getting them to read it, acknowledge it and come back, you're asking them to take, again, that's about testing their commitment to the organisation. So them taking the time to be able to do that. You know, some people will get all that sort of stuff in our experience and they'll go, yeah, look, this business is, you know, they got it together. They're well organised, they're sorted, you know, they prioritise safety, they've got a good framework in place. This is the type of place I want to come and work at. Yep, they're going to make their employees accountable for their actions in the business. Okay, so that's really, really good. The second part of it, the first part of it, the second part is that those employees might look at it and go, oh, do I have to go through all this rubbish? It's just BS. I'm not going to do it. It's not the place for me. And if you've got an employee that does that, then potentially they may not be the right fit for your business. So you'd much rather know that 1 or 2 weeks out of start date than have that when they actually get to site and they've been with you for a week or 2 weeks and you're chasing them up to sign the staff handbook and they're saying, oh, I don't believe in that crap. What do you know, this isn't the Qantas. What are you trying to do? You know, this is a load of rot. Okay. And then you've got to deal with them on site as a paid employee. So that's probably the benefits in terms of doing that. Make up a starter pack, as the tip suggests, and complete as much as you can prior to the new employee commencing. And we've got some questions.
We do indeed. Kerry, would you like to? I see your hand is raised. We'll start with your question if you'd like.
Okay, so what have we got?
My question is, in the commitment phase, if they say that their fitness for work, let's say that they have acknowledged they'll accept the job, and then after you're doing all your paperwork, they say, look, I've got chronic leg pain, and I notice you've got stairs upstairs. Are you able to then not go to the induction phase?
You don't have to, Kerry. So you can so if they fill in that compliance information when it comes in, and they say that they identify that they have a pre-existing injury or illness, even if they've signed the letter offer that's come in, what that does is it actually triggers your ability to be able to then send them off to a medical if you want to, okay, or ask for a pre-medical. Okay, so the mere fact that they've signed the document, they haven't commenced work with you as yet, okay? All right, so they're not technically employee at that point in time until they actually commence work, okay? So you could at that stage withdraw the offer, or it could lead to you taking further action just to test at that point in time, Kerry, and guys online, to test if you need to, what other information you might have to gather from them.
So really we should do this in 2 steps. So you put say an afternoon aside to do the commitment stuff, and then try and have a breather and do the induction later?
Yes.
Yep, okay. Thank you.
Yep, that's right. Yep.
I think that question
exactly right.
Really well onto Trevor's question is, are you able to request a medical examination / clearance before they commence?
Short answer is yes, you can, Trevor. Generally, you would need reasonable cause, but depending on the role, if it's high risk, so let's say it's a planned operation, okay, then yes, you could, because the role itself would give you reasonable cause. Leading back to Kerry's question, if something came through in those documents in relation to illness or injury, which you've asked them to identify, then that would be reasonable cause as well, Trevor. Yep.
Fantastic. We've got 2 more. So the next one is, do you recommend work trials as part of the recruitment process? Are they effective, and do they leave the business open to risk?
So with work trials tests, depending, like there's some work, I'm not sure what you may think is a work trial, but generally if someone comes on board, okay, and they start performing work for you as a general employee, okay, then they're on obviously work time and they're being paid. Test. So in relation to a trial period, that's really, I suppose, what you would call a probationary period. Okay, and we're going to talk a little bit later in the session in relation to these minimum employment periods and unfair dismissals and all that sort of stuff. So for me, when you bring someone on board, if you've done that recruitment as best as you possibly can up front, Test, then they would go under a probationary period anyway, which can be 3-6 months, depending on what you designate, okay? And you can still make a decision as to whether or not they're going to work out for the business or not. So they really are on trial, Tests, if that makes sense. I don't think I can see Tests because I got, hang on, that recording has popped up, but the Test is there on somewhere, I think.
Yes, I can see Tess. She's just down in my bottom corner. Final question, and then we'll move on, is, is there a template of questions for the interview and the referees that can be shared?
Yes.
Or,
Yeah. From me, you want something from me? Is that what the question is?
Yep.
Yeah, certainly. Yep. I can help you guys out with that. Yep, for sure.
Good. We'll send that out in the post with the recording.
Yes, please. Yep.
Excellent. Very good.
Okay.
And that's it for now.
Okay. Thanks, guys. Good questions. The next phase, as the title suggests, the next part of the webinar is about looking at the risks associated with managing or dealing with your employees, essentially on a day-to-day basis. and hopefully we can provide you with some tips so that you don't end up before the Fair Work Commission, QCAT, or have the Ombudsman knocking on your door wanting to do a time and wage inspection. So basically, for this part, we've broken the risk down to essentially two sources. The first part, as the slide says, is wages and conditions, so disputes over the wages that we pay someone and or their working conditions is the cause of concern or issues in the business. And the second part is obviously the people problem. So, you know, sometimes we see that the oil's leaking out of the tractor. That's fine. We know how to fix that. But because we're dealing with people, we don't always know what the source of the problem is or why we've got a problem there, okay, with our employees. And so, you know, trying to identify, so it's probably a bit similar to fixing the tractor, and you're trying to identify then the problems and then the sources and fixing it. It's exactly the same when it comes to people. It's just a hell of a lot more complex to do. That's all than fixing the tractor. All right. So wages and conditions. There are about 121 modern awards, guys, in Australia. They're based or broken down on an industry basis or an occupation, or can be both. Awards cover most people who work in Australia, and generally to be covered by award, you're found to be in a particular industry or a business that's covered by that industry in the award. And the second part of that is you're actually found in a job classification that is found under that award, okay? So there are still people that are award free. I will say, don't hold me to this, generally it's up into that professional managerial level. But having said that, there is a professional employees award, there's a miscellaneous workers award, and so some managerial positions are still found within certain awards. Okay, so what we call the SHADS award, which is the Social and Community Services Disability Sector Award, it covers the Chief Executive Officer of those organisations. Okay, I've just used an example. It's the Pastoral Award. I'm not saying that it'll apply to the people that are online today. It could be the Horticultural Award. For administration staff, it could be the Clerk's Private Award. I suppose the purpose of this slide is to let you know that as a business, it is your legal responsibility to ensure that the right award is identified and applied correctly. Now, I know that's not always an easy task. I've been doing this for 23 years. Tracy, my wife, who works in the business, has been doing it for 32, and we've never seen a more complex workplace relations system, to be quite honest. And we've never seen the awards more complex than what they are at the moment. And so that's coming from me, who's a practitioner in the field. So ensuring that employees are correctly classified under the right modern award is really important. I've got a client in Brisbane who has 30 employees and, no joke, covered by 5 awards. 30 employees and covered by 5 different awards. It's just crazy. Employers in the agricultural or horticultural sector, it's probably a little bit easier in terms of finding the correct award that applies. It just depends on the nature of your business, how you've structured, particularly your operations, whether you've got some off-farm operations or they're all on-farm, or you've got other associated businesses that may operate through the company. And of course, so we've got a correctly classified employee, and what that does is obviously help us work out what the minimum pay and conditions are as provided for under those awards, because as a matter of law, we have to be meeting that at all times, those minimum pay and conditions under the award. Couple of tips there. Scoping out the primary purpose of the role, the main tasks and duties will help you classify them under the modern award. Now, guys, if you do that entry into the business with some planning, you already have the PD, okay? So you use that position description and then you look at the award and apply it to the award. That'll help you try and find the classification level under the actually under the award. Once you've got them classified, you'll be able to then work out their minimum rates of pay, because that'll align to a rate of pay under the award. All right. Letters of engagement, contracts or agreements. So again, they're all just mechanisms or names used to express what the terms and conditions of employment are. So whether you decide to pay in accordance with the modern award or above the modern award, or you create an annualised salary arrangement, what's important, guys, that you must make sure that the employee is at all times not receiving wages and conditions less than those provided under the modern award. Okay? So what that means is that there's still some views floating around that if I just pay someone above the award and I put it into an annualised salary and I call it a salary, I don't have to worry about the modern award. That's not correct. Okay? The modern award, if the employee is covered by the award and there's a classification there for them, they must be paid at all times no less than what they would have earned under that modern award. Okay, so you can do this wage modelling and say, well, I'm going to pay you, 60K a year, but you have to, or you should, actually test that against what they would have earned under the award. So you've got to do the maths, in other words, to work out and make sure that if you're going to do an annualised salary, that it's going to well and truly cover what they would have earned under the award. The old days was if we pay them a salary, you don't have to do the award. That's not the case at all, guys. Not the case at all. Doesn't mean you can't do a salary. Call it that. But you've just got to make sure you meet the award. Okay. So whatever mechanism you use, write in plain English and be concise. We as consultants prescribe to the simple, straightforward letter of engagement rule. Not so much the 30, 40-page legalised employment contract document. To us, that doesn't give you any sort of extra level of protection as a business. In fact, it sometimes just creates greater ambiguity as an organisation. Record keeping. That's the other really, really important part or obligation that you have as a business owner or manager. So proper wage keeping is really important. So as the tip states, if you establish an annualised salary loaded rates, still keep a timesheet with the breakdown of the hours that are actually being worked. And you do that so you can actually audit yourself. It is just an extra level of protection for you as a business. So you can actually see what hours the employee is doing, and then you can look at what the annual salary is, and you can audit it yourself and make sure that you are not underpaying them, because you don't want the ombudsman knocking on your door and them doing the audit for you. Okay, so you'll pick that stuff up, any underpayment of wages yourself, if you do it that way. But the the record keeping obligations are basically the general stuff which you'll get as part of the onboarding and recruitment phase. So that's just the employee details, the superannuation, commencement date, type of employment, timesheets that record the hours of the work, the breaks and the overtime, etc. Any leave, make sure you've got a record of leave that's taken, so sick leave or annual leave, parental leave, and pay slips. So look, the Act requires that you do have certain information on the pay slips, okay, and then the Ombudsman gives you an example. If you go on their site, they'll give you an example or a sample pay slip that'll show you what they say is best practice. I like what the Ombudsman's got on their site in terms of best practice, and that's what we would advise you guys to do in terms of issuing a pay slip. So, for example, the law says you don't have to put a leave balance on a pay slip when you issue it to an employee, okay? You don't have to put the sick leave balances on there. If they take sick leave, yes, you've got to show it, obviously, but you don't have to show that sick leave sitting there and accrues, every year and it's rolled over, etc., etc. Some employers at best practice do it, okay? They just put the accruals on there. If they've got a system, an accounting system, a payroll system that allows them to do that, they just let that roll over. I've had some clients say to me, why would we? I don't want them to know, Jay, how much sick leave they've got. I said, well, I've got a right to know anyway. So what's it matter if it's on there? Otherwise, they're just going to be asking you to tell them how much sick leave that they've actually got. All right. So there's pros and cons, but I wouldn't be frightened of sharing as much information as you can in terms of the pay slip. Okay.
We have a couple of questions in the chat, Jay, if we were able just to answer them quickly. So
Yep.
One of them was in regards to slide 10, which is the slide on onboarding. The tip down the bottom says make a starter pack and complete as much as you can prior to the new employees commencing work. Is this unpaid? That's a question from Kerry.
Yes. Yes, it is. Yep,
Fantastic.
because they haven't started with you. Correct.
Very good. And then Rupert has put a question in. Jay, have you any insight into Fair Work's interpretation of the common provision of a package to employees of base wage, housing, rations, etc.? Do the housing and rations value contribute towards meeting minimum hourly rates under the award, i.e. the pastoral award?
We're talking particularly about the pastoral award there. Rupert, I need to look in that a little bit closer. I have dealt with that before for another client down in Warwick. Don't hold me to this, mate. But the housing and the rations does not offset against meeting the minimum terms and conditions under the award, mate.
So I'm not the only one bamboozled by that one then, hey?
Yeah, you're not the only one that's bamboozled by them, but we did have, like I said, we had a look at it for a client in Warwick, covered under that award.
Yep.
And they asked me that question. This was about 12 months ago there, though, mate. And no, the short answer is no, it doesn't. There is some, I know there's some particular strange wording in that clause about how that actually operates. Yeah, it's a bit tricky. But yeah, mate, that's the best answer I can give you today.
Okay, too easy. Thank you.
No worries. The other part of the risks associated with managing people on a day-to-day basis is obviously the people problem. So this is the hard part. So so managing conduct, capacity, and performance issues is one of the can be one of the most challenging parts of your business. It's time-consuming. Like I said, the employment laws are really complex. The rights of employees have never been greater since I've been kicking around anyway in this game. There are two main areas that we provide training for organisations on a fairly regular basis, whether they're small, medium or large. One is how to effectively manage employees. And the second one is promoting safe workplaces, which is about dealing with bullying and harassment and discrimination. And the reason why that they're popular training courses or we get used a lot in that particular area is really because of this, is how to deal with the people problems. So because we may not have the knowledge of the skill experience, we might be really good, at animal husbandry or whatever the particular skill set that we might have, or accountancy or whatever it is that we got, doesn't always make us the best people managers. Okay, so we might not have the necessary skill and knowledge to manage the people. The other part of it could be we might not have the time to do it. Okay, because we're busy running the business or running the organisation. We don't have to deal with that silly, bit of conflict that occurred last week, in the smoko room. All right, and so we may not then have the confidence. And what we find in our experience, that what happens then is people just basically opt out. They just don't deal with it. Okay. Now, just quickly, when I use these terms, conduct, capacity and performance, just to let you know, there's some definitions, some general definitions there for you. So when we talk conduct, capacity and performance, the Fair Work Commission talks about it, okay, when you deal with unfair dismissals and general protection claims. So to give you an idea what they mean, conduct is just that. So it's generally misconduct matters, stealing, fighting, bullying, abuse. Capacity is a little bit more tricky. So capacity is about, it could be an illness or injury that a worker's got. It could be someone's lost their driver's licence. So do they have the capacity to perform their job if a driver's licence is an essential requirement? And performance can overlap with conduct and capacity as well. Or could be capacity could be a cause to a performance issue. Things like being continually late, making mistakes, not performing the tasks properly, not meeting the deadlines on time. So there's some examples for you of performance. So when we opt out, if we're a business owner or manager, when we opt out of these people problems, what it does is give rise to risks in two areas of your business. One is culture and the other one's industrially. So that's the claims that employees can make against you. Okay, so culturally, we're talking about, where you're potentially condoning poor performance or conduct because you haven't addressed it. That has an impact on then other employees within your business and your organisation, because they say, hey, look, Jay's late every 10 minutes, so why should I bother? I might just sleep in. No one cares at this place, whether you're late or when you turn up to work. So that impacts on your culture. And then what it can do is reflect poorly on you as a business or as a leader within your business, whether you're the owner or the manager, and they can say, oh, look, they don't know what they're doing here. I'm gone. I'm out here. I'm going to another place. The other side of it, of course, is the industrial claims, and those four are the most common. The ones in the red are number 1 and 2. But unfair dismissals and general protections, which we'll talk about shortly, workers' comp and bullying, harassment and discrimination. How do we fix it? Simplest way to manage your workforce is to have a framework in place, guys. And I know as businesses you're busy, running the business and trying to make money as best as you possibly can with whatever it is that you may be doing. But it's really important to obviously invest in the HRIR side of things, and of course that's why you're here at the webinar as well. So a framework is made up of 2 things. Process, which is your bricks and mortars, okay? So your staff handbook, your code of conduct and your policies and procedures, because what that does, it tells the worker, okay, and so this is contractors as well as employees. You can have the one document cover both. It spells out for them what you expect from them in your business. So it sets the work rules. The other part of it is the people. So there's no use having the bricks and mortar and you've got no one living in the house or being able to actually maintain the bricks and mortars. So having your workforce trained in your staff handbook and your policies and procedures, but in particular, if you've got managers, depending on your structure, or you're the owner and you're running the business yourself, okay, as the owner, having yourselves trained in terms of how to effectively manage these employees, okay? And that term there in blue, reasonable management action undertaken in a reasonable way, I don't know whether you've heard that term, but essentially it's a term that we use that if we have a robust framework in place and we do things properly, then we have a defence, a general defence, on the basis that we're reasonable management action undertaken in a reasonable way in terms of claims that may be made for employees. The tip again is to keep it simple, concise, straightforward and usable. Okay. So have we got any questions? Zabby's got one.
Can you read that, Jay, or would you like me to read it out for you?
Yeah, we've just done this. We have just done this and we are told we can deduct, after we've calculated the minimum wage is calculated. Correct. However, all other benefits are not included in the minimum wage. Would be great to know if this is correct as well. Yep. Okay, Zabby. Well, I'll have to look into that. It's a particular, like Rupert said, it's a particular confusing or tricky section of the pastoral award. Yeah, that we need to look at. But I can look at that for the group. Yeah. Is that okay?
That would be great, Jay. There's one more Tess has just asked if you can read that. Perfect.
Yes, it does, Tess. Yes, it will. Yep, certainly. So you just adapt. So Tessa's question, the videos work as well in terms of providing that information, particularly to people of non-English speaking background, legally stand up. Yeah, it certainly does, Tess. Yep, because the key here is about communicating the information in the correct way where the people have the best opportunity to understand what's being said. Yeah, or what's being provided to them.
Just quickly.
All right, guys, how are we going for time? We've got about 4 minutes left.
We've got
Meg?
4 minutes left, but I don't want to cut you short, Jay. So if anyone needs to hop off, we'll continue the recording and finish Jay's slides, if that's okay with you, Jay. And then cut off once we've all wrapped up, if that suits. Fantastic.
Yep.
Let's keep rolling.
Stage 3, so this is the last phase in that employment work cycle that we talked to you about. So as you can see from the slide, exiting a business as a worker doesn't just cover what you traditionally think would be, either resign or the business sacks me. So there's a range of other circumstances and scenarios you can just see on that slide that may lead to an employee exiting the business. Just a tricky one for the group out there, maybe a tricky one. Can anyone tell me what constructive dismissal is? You probably understand what the rest of it is, but can anyone tell me what constructive dismissal is? Or might know what constructive dismissal is. I'll let you think on that one. And also maybe summary dismissal, if you think you know what summary dismissal is. whack that down on the chat as well. Okay, so the common legal claims, unfair dismissal. Rupert's got it. Yeah, leaving the employee with no other choice but to resign. Correct. So that's what a constructive dismissal means, where the employee argues that they've been unfair. So it's an unfair dismissal application made on the basis that the employee had no other option but to resign. So you see it sometimes in cases where they say, I've been bullied at work and I've made a complaint to my employer about it. They've done nothing about it. The bullying's continued. I've made another complaint. I can't work here anymore. I've got no other choice. I've got to get out of here, sort of thing. So they're very hard to prove. Very hard to prove. We've dealt with a few of them over the years, defended quite a few of them over the years, because there generally is something that the employee can actually do. But yep, Rupert is spot on. And what about summary dismissal? If anyone can tell me what a summary dismissal is, it'd be really good as well. So those common legal claims, guys, unfair dismissal and general protections, they're the two most common. So according to the Fair Work Commission, remember that's the tribunal that deals with these matters, in accordance with their recent report, there's about 13, so this is 2020-21, about 13,281 unfair dismissal applications, so it's the most common. General protections next at about 4,100 claims. They were down actually from the report from the year before. I'm not sure why, but they were down. Maybe because a lot of people weren't working, perhaps, with COVID and things like that. I'm not sure. But anyway, they can be time-consuming and costly exercises as a business to go through. And so whilst you may not be able to prevent an application being made, as a business, what you can do is put yourself in the best possible position to defend it, particularly those claims that are without cause, or what we call frivolous or vexatious. And whilst the majority of applications are settled at a conference stage, so you go conference then into trial, there's a couple of steps there, guys. Majority of them are settled, and don't go to trial. There's still some level of compensation that's actually awarded to the employee that's made the application. So that's still very much in the majority. And the reason why is that, well, basically a lot of businesses just make a commercial decision, even though they might be in the right. It's cheaper to pay the employee a couple of weeks' pay than it is to engage some highfalutin lawyer or advisor that does webinars to represent you in a trial at the end of the day, and pay them money to be able to do that. And that's the reality of it. That's how the system is built. Unfortunately, it's not a system that's really supportive of employers, in my experience. It's more so supportive in terms of employees. But having said that, we've obviously been quite successful in defending claims. And the reason why, though, is that if you pick up this preventative backburning stuff first, then you'll have the biggest gun in the room, so to speak, if I can use that term. So you'll be in the best position to be able to walk into a conference and say, no, we're not going to cough up any money here. We might let them resign, show the record as a resignation. Type of remedies under unfair dismissals: compensation up to a maximum of 6 months, reinstatement or re-employment. This next point, minimum employment periods. So coming back to, I think, Tessa's point about work trials. So small businesses are defined at the moment as less than 15 employees, but that includes a head count, includes casuals, it includes any directors that are drawing a wage from the business, okay? But if you're in that category, then you've basically got a 12-month probation period, if I can use that term. So you have 12 months in which you can terminate an employee, and they don't have recourse in terms of unfair dismissal. For those employees that are 15 and above, okay, then they've shortened that to 6 months. So those businesses have a shorter period of time. Okay, so what a lot of our clients are doing is they're still having a probation period of 3 to 6 months, or it doesn't matter which one. They're still doing reviews after 3 months, even if it's a 6-month probation review, and still making a decision, as soon as they possibly can, whether or not a person is working out within the business. But that's just to let you know there's some level of protection against unfair dismissal because of these minimum employment periods. Now, having said that, employees are really smart, so they go online, they go to the lawyers, or they go to the advisors, or they go to the ombudsman, and then they get some advice. They say I was dismissed, and they say, well, how long you been there? I've been there 6 months. Are you a small business? Yep, they're a small business. Oh, okay. Oh, all right. So, have you got any concerns about whether it was discrimination or you exercised the workplace? Oh, yeah, I complained about my wages the other day, and then they sacked me 2 days later. Oh, okay, so that's a general protections claim. So this is the other type of claim that pops up. So this is where an employee claims that their dismissal was essentially unlawful or illegal. And it's because I was terminated because of my race or my religious beliefs, the colour of my skin, all those discriminatory attributes. And you were terminated because you exercised a workplace right. And there's some examples of that. So it's pretty broad, that term. But exercising workplace right could be as simple as I went into the manager's office and complained that my wages were not correct. That can be exercising. So that's making a complaint, which is exercising workplace right. The other obvious examples of exercising workplace right is taking sick leave. I was sacked because I took sick leave. I was sacked because I lodged a workers' compensation claim. They're the more obvious examples of what that is. The issue with general protection is it's a really serious form of a claim a worker can make against a business. The remedies are compensation, uncapped, reinstatement or re-employment. So they talk about damages. You don't talk damages in an unfair dismissal case. They talk compensation generally on the basis of lost wages. When you talk about general protections, they talk about lost wages, and they also talk about damages as well. There's no minimum employment period here, guys. So you employ Jay on day 1. On day 4, Jay's not working out. You terminate him. Jay on day 4 can lodge a general protections claim. There's no small business exemptions. And there's what we call the reverse onus of proof. So you don't find this in many areas of the law. But what that means is basically if you terminate me on the 4th day, and I believe it's because of the colour of my skin, it's not because I was turning up late to work. If I make that claim in the commission, the business is presumed guilty. So we have to, as a business, prove otherwise. We have to disprove the claim. Whereas an unfair dismissal case is I claim I was unfairly dismissed and I have to prove I was unfairly dismissed. Okay? General protections is I claim that I was dismissed for unlawfully, and now the business has to disprove what I'm saying. Okay? Two basic rules apply to your business when you're looking at ending, or if you're even if you're disciplining an employee or warning them. Okay, the first one is substantive fairness. Do we have a valid reason for taking the action that we want to take, the adverse action we want to take against the employee? And the second one is, have we gone through a proper process, which is procedural fairness? And if we do that, it's reasonable management action undertaken in a reasonable way. Substantive fairness, the next slide there, guys. So a valid reason. That means we've established the grounds and reasons for the termination, and does the punishment fit the crime? So there's plenty of cases, guys, in the Fair Work Commission and the courts for that matter, where businesses have had a valid reason. So people have engaged in misconduct or serious misconduct, which warranted dismissal. But because the business went out there and tapped them on the shoulder and said, you're gone, pack up your gear, you're out of here, and didn't go through like a show cause process, didn't write to them, tell them what the allegations were or what the issues were, give them an opportunity to respond, the termination has been found to be harsh, unjust, or unreasonable. So you cannot have one without the other, guys. That's what that means. So even though you may have a valid reason to dismiss someone, you need to go through a show cause process first, okay? Now, you don't have to do that in that first 6 or 12 months, depending on the size of your business, because they don't have access to unfair dismissal. But it's still best practice to do it that way, okay? Because what it does is it helps protect you against a general protections claim, because when they realise they can't file an unfair dismissal, they'll go down a general protections path, okay? The tip, the framework, the policy, and the business owners and the managers are properly trained on how to effectively manage employees. So like I said before, so having that framework is we've got the rules of engagement or the rules of the business, and then on the other side of it, we've got managers, supervisors or business owners that are competent and confident and have the time to step in and deal with any conduct, capacity or performance issues before it all blows up. Large part of our business is workplace investigations, guys, and I can tell you now, for 23 years I've been doing them. 9 times 8, well, I won't say 9, I'll say 8 times out of 10, I am investigating an allegation of bullying that has been born out of some trivial conflict in the workplace that wasn't managed at the time or in a timely manner and sorted out, guys. So the more competent and confident you are in this area, the easier it's going to be for you to step in and deal with any conflict in the workplace or any conduct, capacity or performance issues before it gets out of hand. Okay? Any questions in relation to that? Sorry, a bit rushed at the end there. Thanks for hanging on for some of you.
There's no questions in the chat currently, but if there's any questions that come through, they can direct to you, Jay.
Yeah, absolutely. Emails on.
Yeah, your email's there. Yeah, exactly. And then we'll also, as part of the webinar series, we're also running a podcast series. So any questions, like reoccurring questions and things that came up today, or Jay would like to provide more information on, we'll do so in the webinar, in the podcast series. So I would like to thank everyone for joining us today and appreciate you taking the time to be here. We really do care about your opinion about what you thought of today. So I'll be sending out a post-webinar survey along with the webinar recording and any notes, including Jay's template for questions for interviews. As I said, if you have any questions, please get in contact with Jay or myself and we'll work out a solution from there. And yeah, I think that's all wrapped up nice and neatly. So thank you, Jay. Thank you everyone for joining us today. And
thanks, Meg. Yeah. Thanks, everyone. Enjoy the rest of your day.
You too. Bye.